Hello, guys. Welcome to the fourth part of Reading Steam's subscriber agreement. Let's jump into it. Number 8, amendments to this agreement. Please note if you're a consumer with the place of residence in Germany, a different version of Section 8 applies to you, which is available here. And there's a button to there. Uh, I'm going to read on. A mutual amendment. This agreement may at any time be mutually amended by your explicit consent to changes proposed by FOF. So, just a little recapitulation before we proceed, because we gotta get into the mood or something. Okay. So the last video I've read about Steam subscriber agreement and stuff, and it's about the legal documents in Steam. I've made three parts of it, and up until now we have read the disclaimer, the limited liability, and I've also talked about how Europeans or the European law is actually contributed a huge deal in the relationship between gamers and content providers, which in my opinion, consumers are like from outside of Europe are also advantaged by this thing, like the privacy policy and also the like the infrastructures that big authors or big providers of services must be prepared to with dealing with the customers rights, right? It's like kind of being enjoyed by people outside of Europe as well, outside of America as well. So so I am not a European, and I enjoyed quite a lot um, of that kind of relationship, right? I'm sorry if you expect a lot of reading in this video. Instead, I'm talking right here. I'm going to get into the reading a bit more. Oh, I'm spitting everywhere. Um, yeah, I just want to get into the mindset real quick because I haven't been done this for a long time, and I also need this to get myself into the groove, let's say. So now after we read the limited warranty and agreement, we would proceed on to the amendments to this agreement. So we want to know what are the cases that this agreement could be changed, because after all this reading, right, after all this effort of getting through the legal documents, tomorrow the legal documents is changed, and then you have to start all over again. That is kind of costly actually, but they could do that at their own volition, right? But usually I would expect them to say, like, we'll give you upfront notice or something like that. So I would expect that in this chapter as well. A. Mutual amendment. This agreement may at any time be mutually amended by your explicit consent to changes proposed by FOF. B. Unilateral amendment. Furthermore, FOF may amend this agreement, including any subscription terms or rules of use, unilaterally at any time in its sole discretion. In this case, you'll be notified by email of any amendment to this agreement made by FOF at least 30 days before the effective date of the amendment. You can view the agreement at any time at steampower.com. Your failure to cancel your account prior to the effective date of the amendment will constitute your acceptance of the amendment terms. If you don't agree to the amendments or to any of the terms in this agreement, your only remedy is to cancel your account or to cease use of the affected subscriptions. FOF shall not have any obligation to refund any fees that may have accrued to your account before cancellation of your account or cessation of use of any subscription, nor shall FOF have any obligation to prorate any fees in such circumstances. All right. Okay, so this is a little bit as a spirit from the disclaimer before in was it first or chapter 7 in number 7, right? They want to secure their position by telling this upfront to us, right? There's no guarantee of especially in terms of monetary compensation or any kind of compensation to you, if they wanted to change the terms and condition. Just because they change the terms and condition doesn't mean they need your doesn't mean that they need your permission again. Um, they, you this relationship would have expected us to actually, as soon as we got the 30-day notice, as soon as we got the notice in the email, we would, we would know whether to accept or to to refuse. And if we were to refuse, we would just uninstall and everything. We don't have any more demands and stuff. Probably, let's say, for example, in Dota, you can trade goods, right? Gaming goods in their market, right? There's a market, and it uses like kind of some kind of gaming money, Steam money, and it's kind of money. So you can put in your stuff right there, and you would expect that within 30 days the price would go up, and then Steam notify you that they they would change the terms and condition. Now, when you sell this stuff, you probably have bought it for cheap, right? And because you disagree with some of the terms, then you would like, oh my god, I have already spent all of this money for this item, and now I would have to close the surface. This is kind of problematic for me, so I would expect probably, somebody to pay all of these items back, because why are you changing your terms and conditions while we already have an agreement before? Why are you suddenly changing it? But with existence of this point 8 right here, they've already explained it upfront to you, so you would like that you should take this into your anticipation, in your equation, in your account, that such risk exists. So before you buy all of these items in order to sell it later, you would know that this is your risk, right? Upfront, you already know that this is your risk. So if the risk took place, it is already um, you've already anticipated this. That is that's somewhat the expected. You know, again, I am not an expert. Okay, I am definitely not comprehensive on this. There's there should be some deeper understanding, deeper and more nuances, or not only nuances but details and backgrounds regarding this, but I'm just sharing what I could understand. Then number 9, term and termination. 8, term. The term of this agreement commences on the date you first indicate your acceptance of these terms, and will continue in effect until otherwise terminated in accordance with this agreement. Okay, so what's the difference between changing the term and terminating? B. Termination by you. You may cancel your account at any time. You may cease use of a subscription at any time. Or if you choose, you may request that FOF terminate your access to a subscription. However, subscriptions are not transferable. And even if your access to a subscription for a particular game or application is terminated, the original activation key will not be able to be registered to any other account, even if the subscription was obtained in a retail store. Access to subscriptions ordered as a part of a pack or bundle cannot be terminated individually. Termination of access to one game within the bundle will result in termination of access to all games ordered in the pack. Your cancellation of an account or your cessation of use of any subscription or request that access to a subscription be terminated will not entitle you to any refund, including of any subscription fees. Fourth, reserves the right to collect fees, surcharges, or costs incurred prior to the cancellation of your account or termination of your access to a particular subscription. In addition, you are responsible for any charges incurred to third-party vendors or content providers before your cancellation. FOF reserves the right to collect fees, surcharges, or costs prior to the cancellation of your account or termination of your access to a particular subscription. In addition, you are responsible for any charges incurred to third-party vendors. You are responsible for any charges incurred to third-party vendors or content providers before your cancellation. Okay, I don't really I don't think I've comprehend entirely what is trying to be secured here. Of course, you should finish all of the transaction, but what if you don't finish the transaction? What if there's something lingering after the termination? What would that be? Your cessation of use of any subscription or request that access to a subscription be terminated will not entitle you to any refund, including of any subscription fees. So in Dota, again, I use Dota as an example. There's this thing called Dota Plus, and it is like there's a period of subscription. It's a subscription. So it could last for as long as a year or 6 months. And while in the middle of it, if you terminated it, I guess you've already know now that you don't get all of the money back, even partially. C. Termination by FOF. FOF may restrict or cancel your account or any particular subscriptions at any time in the event that FOF ceases providing such subscriptions to similarly situated subscribers generally, or you breach any terms of this agreement, including any subscription terms or rules of use. In the event that your account or a particular subscription is restricted or terminated or canceled by FOF for violation of this agreement or improper or illegal activity, no refund, including of any subscription fees or of any unused funds in your Steam wallet, will be granted. Okay, so this is on false initiatives, right? You breach, if you breach the terms of use, but then, right, there's going to be cases where it is disputable whether or not you violated something, or even if there was violation, it was justified for a good reason, or for something, it's something that's supposed to be legal, or something that is supposed to be legally advocate advocate advocable. I don't know. So upon that event, is it also being covered by this point, right? Even if that is the case, even if it is disputable, you should expect probably that FOF would do something like this. And after that, whether or not you are entitled for a refund or not, I don't know. Again, this is deep stuff. This is lawyer stuff. Okay, termination and stuff. But luckily, the money involved is not really that big in terms of Dota Plus subscription. Usually, it's not worth it. But so me reading this is just reminding you, why would you hire a lawyer for $10, for example, right? But it's nice to have known this, right? It's nice to have known that if you violate a terms and condition, or deemed violating a terms and condition, you could lose some $5 worth of money, right? Okay, D, survival of terms. Section 2C, 2D, 2F, 2G, 3A, 3B, 3D, 3H, and 512 will survive any expiration or termination of this agreement. So let's see. Come on, let's see. 2C, what is 2C will survive. 2C, 2D, let's see. 2C, 2D, 2F, 2G. 2C, C, D, F, G. E will not survive. 2C, what is 2C? License to use FOF developer tools. License to use D. License to use FOLF game content in fan art. E will not survive. E, license to use FOLF dedicated server software. All right. So license to use game content in fan art will survive the termination, right? So you still have the license if even if the service was terminated. Um, Ownership of content and services. F and G, restrictions on use of content. Okay. Even if you are no longer in a customer provider relationship with Steam, all of the restrictions still applies to you in this terms and condition. Well, I think um, even if you are not a user in the first place, meaning that you've never read these terms and condition before, you still could not take away somebody else's intellectual property. But the fact that you've used Steam and you have played a game on Steam makes it that you are also under. Is it true or not? You, even after termination, you would still be. You would still okay. You would be under the terms and condition. You would be under these terms and condition. Okay, and you've agreed to this section 2c 2d to f to f to g 3a, survival of terms, right? This is kind of controversial, right? Is as much as it is acceptable or it is reasonable, the things that is said in these points, right? Let's go again. 3a 3b 3d, 3a 3b 3d. But it's still like mm, a little bit unsettling, right? Or a little bit questionable or sus. This is my personal opinion. And then 3A, payment authorization. Okay. But it's necessary, I guess. Like this, for example, payment authorization. You are, even if you haven't played any game again, you have uninstalled Steam and such, the license to regarding payments and stuff still applies. I think that was necessary. 3D, trading and transaction of subscription between subscribers, like the market, right? Um, what again? I I forgot. 3H 5 to 12. 3H is this. Wait, 3H is third party sites. Steam may provide links to other third party sites, makes no represented and warranties. Okay, so Valve is still, even after, like, if you suffered damages from third party site that you access through Steam services, and then you terminated the relationship between Steam, you still want to, like, um, you still want to the disclaimer that the Steam, that's Valve, it's not responsible for that particular relationship, still remains. um and 5 to 12, third party content, user generated content, um disclaimer, limitation of liability, term and termination that we are just reading, applicable law, attorney fees, dispute resolution, which we haven't read yet, and it regarding, and miscellaneous also remains after termination, will survive any expiration or termination of this agreement. A lot of this is reasonable, but I do think there are some issues on it, right? Again, like what I said before, if you haven't being a Steam subscriber initially, and then you started to play the game of Steam, you would get into some kind of, what do you call it, different situation. Even, and when the relationship got terminated, you are not legally in a position, in the same position as you were before having a relationship with Steam, right? So Is this normal? Like the most extreme, like one of the most extreme spectrum of this is I would imagine divorce, right? Before you are married, you are single, you have all of these responsibilities and rights. After you got married, you are different in terms of the society, in terms of the law, in face of the law. And after you are divorced, there are obviously you are not the same anymore, right? You have like this. If you have a child, now let's not go, let's say you don't have a child, you still have like some obligations that you still have to fulfill to your spouses, whether it's male or female, right? So it's a permanent relationship. I would imagine that it would happen in terms of marriages. I wouldn't imagine it would happen too in terms of relationship with online sites. And it should apply as well if you go to public places that is private. Do you know what I mean? Like malls and stuff are private, like private, owned by private companies. As much as it is a public venue, but it is it's owned by private, like whether it is a person or a corporation. So just by having that interaction, just by going to the convenience store, you have changed your matrix or whatsoever. You know what I mean? Like you've changed the quantum positioning of your being. I'm serious about this because legally speaking, well, everything we do, right? As we age, everything we experience, we experience changes. Of course. Yeah, I guess that's just life. But it's being presented so vividly like this. It makes me rethink of how what the course, like the flow of life. Okay, let's go. Number 10, applicable law, mediation, jurisdiction, attorneys' fees for all subscribers outside the European Union and United Kingdom. You and FOF agree that this agreement shall be deemed to have been made and executed in the state of Washington, USA, and Washington law, excluding conflict of laws principles and the Convention on Contracts for the International Sale of Goods governs all claims arising out of or relating to one, any aspect of the relationship between us, two, this agreement, or three, your use of Steam, your account, or the content and services, except that the U.S. Federal Arbitration Act governs arbitration as far as your country's laws permit. Subject to Section 11, dispute resolution, binding arbitration, class action waiver below, you and FOF agree that any claim asserted in any legal proceeding shall be commenced and maintained exclusively in any state or federal court located in King County, Washington, having subject matter jurisdiction. You and FOF hereby consent to the exclusive jurisdiction of such courts. In any dispute arising out of or relating to this agreement, your use of Steam, your account, or the content and services, the prevailing party will be entitled to attorneys' fees and expenses, except arbitration. See Section 11C. Um, okay, so not just these terms and condition, but also the law, um, um, right, the dispute resolution laws of the United States of America, in particular the state of Washington, it would it would become relevant in this relationship as well. Okay, for EU and UK subscriber, in the event of a dispute relating to the interpretation, the performance, or the validity of the subscriber agreement, an amicable solution will be sought before any legal action. You can file your complaint at helpsteampower.com. The European Commission provides an online dispute resolution website for EU customers. Europe EU customers ODR Participation in this website is not available to US companies, which is why FOF is not registered there. Okay. However, FOF is not registered. Why is it? Why do we have to observe the state of Washington's law? And then it says here that FOF is not registered there. What the performance or the validity of the subscriber agreement, an amicable solution will be sought before any legal action. You can file your complaint at helpsteampower.com. European Commission provides an online dispute resolution website for EU customers. Participation in this website is not available to US companies, which is why FOF is not registered there. In the Europe, however, insofar as your complaint concerns the behavior of FOF's data protection representative, FOF GmbH, you can, file your complaint there. However, insofar as your complaint concerns the behavior of FOF's data protection representative, in the event that out-of-court dispute resolutions fail, the dispute may be brought before the competent courts. In the event that out-of-court dispute resolutions fail, the dispute may be brought before the competent courts. 11. Dispute resolution, binding arbitration, class action waiver. Waiver means like you relieve, you are not exercising it, you are stating in that you are not living under that field. Okay. You're relieving. Yeah, okay. This section 11 shall apply to the maximum extent permitted by applicable law. Okay, first, in particular, if you are a consumer who lives in a European Union member country, the United Kingdom, province of Quebec, Australia, or New Zealand, this section 11 does not apply to you. If you are a consumer who lives in Russia, you may utilize the arbitration process identified in the section 11, or you may use local Russian state courts to resolve your dispute. Mind you guys, I do believe that this one is written before the Ukrainian war. Ugh. Most user concerns can be resolved by use of your Steam support site. If FOF is unable to resolve your concerns and a dispute remains between you and FOF, this section explains how the parties have agreed to resolve it. A. Must arbitrate all claims except intellectual property, unauthorized use, piracy, or theft. You and FOF agree to resolve all disputes and claims between us in individual binding arbitration that includes but is not limited to any claims arising out of or relating to any aspect of the relationship between us. This agreement or your use of Steam, your account, hardware, or the content and services. It applies regardless of whether such claims are based in contract, tort, statute, fraud, unfair competition, misrepresentation, or any other legal theory, and includes all claims brought on behalf of another party. However, this section 11 does not apply to the following types of claims or disputes which you or FOF may bring in any court with jurisdiction. Claims of infringement or other misuse of intellectual property rights, including such claims seeking injunctive relief and claims related to or arising from any alleged unauthorized use, piracy, or theft. This one, so this one is being specific in terms of piracy, unauthorized use, intellectual property, or whatsoever. Um, it is a different ways of settling. It is not included in this arbitration clause. It is on its own. I don't know. Probably DMCA. It is something like that. I'm not sure. Wait. How do I explain this, guys? I have no backgrounds whatsoever on this. Okay, but logically speaking, logically speaking, right? There are instances where you could have a problem, for example, payments, such as money doesn't went through and you are already charged, or the game is not delivered, or probably you have a business relationship or whatsoever, and things like that will fall under these clauses, which we haven't read until finished. We should read it until I should read it until it's done. But uh, what I want to tell you is, like, you gotta expect different that intellectual property stuff, DMCA stuff is being treated differently. Um, Usually, from other terms and conditions that I've read, things like that is already included in the arbitration clause. This is, I would say, is something unique, that they separated two types of clauses, for non-intellectual property stuff and with the intellectual property stuff. So I'm curious, what would be the arbitration clause for the intellectual property stuff? How do we solve problems in terms of intellectual property stuff? I guess, like the previous one, like the jurisdiction stuff, already touched on Washington state law, already touched on USA law. I guess before we got that far, uh, there might be arbitration. I don't know. There might be or might not. Let's just read forward and figure it out. Um, This Section 11 does not prevent you from bringing your dispute to the attention of any federal, state, or local government agencies that can, and if law allows, seeks relief from us for you. An arbitration is a proceeding before a neutral arbitrator. So this is not a court proceedings led by a judge. It is led by an arbitrator instead of before a judge or jury. Arbitration is less formal than a lawsuit in court and provides more limited discovery. It follows different rules than court proceedings and is subject to very limited review by courts. The arbitrator will issue a written decision and provide a statement of reasons if requested by either party. You understand that you and FOF are giving up the right to sue in court. Okay, so both parties have agreed that we are not going to sue. Okay, we're not going to sue and to have a trial before a judge or jury. So we agree that we will only use arbitration, not going to court. Okay, this continues on in B to be more clear. Okay, you and FOV agree to make reasonable good faith efforts to informally resolve any dispute before initiating arbitration. A party who intends to seek arbitration must first send the other a written notice that describes the nature and basis for the claim or dispute and sets forth the relief sought. If you and FOF do not reach an agreement to resolve that claim or dispute within 30 calendar days after the notice is received, you or FOF may commence an arbitration. Written notice to FOF must be sent via postal mail to ATTN Arbitration Notice, FOF Corporation, P.O. Box 1688, Bellevue, WA 98004. Um, Something strange though, something bothers me. Something bothers me. You and FOF agreed to make reasonable good faith efforts. Uh, Part A says arbitration is less formal than a lawsuit in court and provides more limited discovery. It follows different rules than court proceedings and is subject to very limited review by courts. The arbitrator will issue a written decision and provide a statement of reasons if requested by either party. You understand that you and FOF are giving up the right to sue in court and to have a trial before a judge or jury. So I guess this is the waiver. right? The waiver of rights. But eventually you gotta like every dispute should be able to be brought to court, right? Like only like I would understand if a terms and condition says at first we go through arbitration, and after, and even if that, and if that failed, we would go to court. But this one is a waiver. It's something new for me. Okay, arbitration rules and fees. The U.S. Federal Arbitration Act applies to the Section 11 as far as your country laws permit. The arbitration will be governed by the consumer arbitration rules or the commercial arbitration rules if the consumer arbitration rule are inapplicable of the American Arbitration Association AAA as modified by this agreement. Rules are available at www.adr.org. The arbitrator is bound by the terms of this agreement. The AAA will administer the arbitration outside the US. FOF will select a neutral arbitration provider that uses these or similar rules. It may be conducted through the submission of documents by phone or in person in the country where you live or at another mutually agreed location. If you seek $10,000 or less, FOF agrees to promptly reimburse your filing fee and your share if any of AAA's arbitration costs, including arbitrator compensation, unless the arbitrator determines your claims are frivolous or were filed for harassment. FOF agrees not to seek its attorney fees or costs unless the arbitrator determines your claims are frivolous or were filed for harassment. If you seek more than $10,000 and the AAA consumer arbitration rules do not apply, the AAA's arbitration costs, including arbitrator compensation, will be split between you and FOF according to the AAA commercial arbitration rules. FOF agrees not to seek its attorney fees if you seek more than if you seek less than 10,000. FOF will reimburse your filing fee, including compensation, unless the arbitrator determines your claims were frivolous. So if FOF lost the claim, if you've proven yourself right, you get the you aside from the compensation, FOF will pay for your filing fee and your share of arbitration costs. Okay, you seek more than 10,000 and the AA do not apply, the AA's arbitration costs, including will be split between you and FOF according to the AA commercial arbitration rules. Whew. Okay, so is it, am I right by understanding that when you do a relationship through Steam, try your best not to involve stakes that's going to rise above $10,000, right? Because above $10,000, if there are dispute, you're gonna have to burn arbitration costs. Whoever wins or lose, whoever wins or loses, what's the grammar here? Whoever wins or lose is going to pay half of the AAA's arbitration costs. Okay. D. Individual binding arbitration only. You and FOF agree not to bring or participate in a class or representative action, private attorney, general action, whistleblower action. So class action is group a group legal suing, or group legal group, like uh, versus a group, right? So FOB versus a group. FOB, we agreed that we would not do that. Kind of cringe, actually. Private attorney general action, whistleblower action, or class, collective, or representative arbitration, even if AAA, so only arbitration, okay? Not court. Not court, but we remember that court stuff has already been waived before. Even if I don't know, it seems like, let me just finish it, okay? Even if AAA's rules would otherwise allow one, the arbitrator may award relief only in favor of the individual parties seeking relief, and only to the extent of that party's individual claim. Individual. You and FOF also agree not to seek to combine any action or arbitration with any other action or arbitration without the consent of all parties to disagreement, and all other actions or arbitration. Okay, so no combining stuff. This agreement does not permit class, collective, or representative arbitration. A court has exclusive authority to rule on any assertion that it does. Well, uh, I guess when it comes to legal issues, the government ultimately can decide whether or not you could, is it a legal contract, or is it an illegal contract? Many cases, right? We have some kind of notice in the end, like if it is illegal, everything else remains. It doesn't terminate the whole terms and condition. You can see that in a lot of terms and conditions, right? They say, like, if one or two things in these terms and the condition doesn't apply, it doesn't mean that everything in these terms and condition would terminate automatically. No, everything else would remain to the extent of its legal power possible, or what, or something like that. I guess we're going to read that this as well in the future. um, One thing that prevents companies from putting in outrageous stuff inside their terms and condition, and also having that clause in the end, is actually, you know is actually something. It's actually something. And are we seeing this case, right? That are we reading an outrageous clause, which then is going to be covered by that special clause right there, the survival of terms clause is going to cover for these outrageous phrases, or terms. I kind of want to feel like it doesn't supposed to be like that. So let me read what I'm trying to convey to you. Okay, you involve also, um, um, in any part of Section 11 is found to be illegal or unenforceable, the rest will remain in effect. So this is part E, okay? With an arbitration award issued before any court proceeding begins, except that if a finding of partial illegality or unenforceability would allow class, collective, or representative arbitration, all of Section 11, okay, which we are reading, will be unenforceable, and the claim or dispute will be resolved in court. So this is a condition where we could go to court, where that waiver that we read before Section 11, right? That waiver can be annulled, okay? I don't know whether annulled is the right word, but you know what I mean in casual sense, right? All of Section 11 will be unenforceable, and the except that if a finding or partial illegality or unenforceability would allow class, collective, or representative arbitration, all of Section 11 will be unenforceable and the claim or dispute will be resolved in court. In any part of, sorry guys, again, in any part of Section 11 is found to be illegal or unenforceable, the rest will remain in effect, except that if a finding would allow all of Section 11. Oh, okay, it is unrelated to the first sentence, sorry. Except that if a finding or of partial illegality or unenforceability would allow class, collective, all of Section 11 will be unenforceable. Wait, why? Except that if a finding or partial illegality or unenforceability would allow class. Section 11 dismisses class action, right? Except that if a finding would allow class. I'm sorry, guys. I'm sorry, guys. I'm curious about this. I'm sorry. I know that the momentum of the video is lost now, but I am curious about this. So I'm going to try again to understand why is this being said like this. Um, what happens if part of Section 11 is found illegal or unenforceable? If any part of Section 11 is found to be illegal, the rest will remain in effect. Okay, except that if a finding of the partial illegality, I guess, or unenforceability would allow class arbitration, all of Section 11 will be unenforceable, and the claim or dispute will be resolved in court. Is found to be illegal, the rest will remain in effect. He said, this is a contradictory. This is contradictory, guys. Take a look at this. Part E. What happens if part of Section 11 is found illegal? Um, if it's illegal, the rest will remain in effect. The rest will remain in effect. Okay? So if there are partial illegality would allow for class arbitration, they will not go to court. Okay? They would prefer to go to class arbitration rather than going to the court, I guess. All of Section 11 will be unenforceable and the claim or dispute will be resolved in court. So in the case of partial illegality or unenforceability would allow for class, collective, or representative arbitration, they would go for that. They would go for class, collective, or representative arbitration, right? But if not, and there is something illegal, they would go to court, supposedly. But there is also this clause again, this phrase again that says the rest will remain in effect. Well, Section 11 is about what? It's about arbitration. So the rest will remain in effect that we should go to arbitration. But then in the end, it says the dispute will be resolved in court. Am I getting this wrong? Is this the extent of my English? I don't think this is made for someone who was exceptionally good in English. I guess this is made for gamers, right? Gamers like me. So I do think this part I is something that I could not comprehend. 12. Miscellaneous. Except as otherwise expressly set forth in this agreement, in the event that any provision of this agreement shall be held by an arbitrator, court, or other tribunal or competent jurisdiction to be illegal or unenforceable, such provision will be enforced to the maximum extent permissible, and the remaining portions of this agreement shall remain in full force and effect. Section 11E governs if some parts of Section 11 are held to be illegal or unenforceable. Except, let me repeat that again, except, this is difficult stuff, man. Except as otherwise expressly set forth in this agreement, in the event that any provision of this agreement shall be held by an arbitrator or other tribunal of competent jurisdiction to be illegal, such provision will be enforced to the maximum extent permissible. Again, like I said, um, like the survivability of terms, right? And the remaining portions of this agreement shall remain in full force and effect. Section 11E governs if some parts of Section 11 are held to be illegal or unenforceable. Also, this is the further explanation. This agreement, including any subscription terms, rules of use, the FOF privacy policy, and the FOF hardware limited warrant policy. Okay, sorry. That's a new sentence. Oh my God. Okay. Section 11E governs if some parts of Section 11 are held to be illegal or unenforceable. So they are not, so the context is no longer about that. That is regulated in 11E. So now, apart from that, this agreement, including any subscription terms, rules of use, and well, maybe not that as well. Maybe not that as well. Maybe that is still included, but further explanation is available in 11E. This further explanation, however, is not that. This agreement, including any subscription terms, rules of use, the FOF privacy policy, and the FOF hardware limited warranty policy, constitutes and contains the entire agreement between the parties with respect to the subject matter hereof, and supersedes any prior oral or written agreements. You agree that this agreement is not intended to confer and does not confer any rights or remedies upon any person other than the parties to this agreement. So third parties are not included. FOF obligations are subject to existing laws and legal process, and FOF may comply with law enforcement or regulatory requests or requirements, notwithstanding any contrary term. FOF obligations are subject to existing laws and legal process, and FOF may comply with law enforcement or regulatory requests or requirements, notwithstanding any contrary term. Okay, wait a minute. I got something in my mind that is off topic. Okay, so I need to clear this one first. I remember something that is important. Excuse me for a bit. Okay, I'm going to read this anyway. Sorry, guys. Uh, FOF obligations are subject to existing laws and legal process, and FOF may comply with law enforcement or regulatory requests or requirements, notwithstanding any contrary term. So they would prioritize dealing with law enforcement and regulatory requests, despite if terms and condition somewhere in the terms and condition found to be like not in compliance to the officials, right? But they would prioritize compliance to law enforcement and regulatory requests, I guess. But he says may. They says may comply. They may comply, notwithstanding any contrary term. Okay, but they would not definitely prioritize, but they may prioritize because they are subject to laws and legal process as well. I'm sorry about that. Moving on, you agree to comply with all applicable import or export laws and regulations. You agree not to export the content and services or hardware or allow use of your account by individuals or any terrorist supporting countries to which encryption exports are at the time of exportation restricted by the U.S. Bureau of Export Administration. You represent and warrant that you are not located in under the control of or a national or resident of any such prohibited country. Such country, if I remember correctly, not in entirety. Okay, among them would be North Korea, Afghanistan, if I remember it correctly, right? But you gotta check out the list. It's probably it could have changed. It could have changed. This agreement was last updated on February 24th to 2022. If you were a subscriber before the revision date, it replaces your existing agreement with FOF or FOF SARL on the day that it becomes effective according to Section 8 above. This agreement was last updated on February 24th, 2022. If and that date is the revision date. Okay. If you were a subscriber before the revision date, it replaces your existing agreement with FOF on the day that it becomes effective according to Section 8 above. Well, so we have just read Section 8 at the beginning of this stream or this video. Okay, so as promised before in the previous video, I am going to read one more thing. Okay, it's in the legal information. It's about like content creators policy and stuff. File video policy, is this the one? We encourage our users to make videos using FOV. I've read this. There's another one. There's FOV legal info. Wait, there's not this one. Excuse me. Okay, let's read FOF video policy again to before ending this session. We encourage our users to make videos using FOF game content such as playthrough or instruction videos or SFM movies. We are fine with publishing these videos to your website or YouTube or similar video sharing websites, sharing services. We are not fine with taking assets from our games and distributing those separately. Use of our content in videos must be non-commercial. By that, we mean you can't charge users to view or access your videos. You also can't sell or license your videos to others for a payment of any kind. You are free to monetize your videos via the YouTube Partner Program and similar programs on other video sharing sites. Please don't ask us to write YouTube and tell them it's fine with us to post a particular video using FOV content. It's not possible to respond to each such request. Point them to this page. Of course, this policy applies only to FOV content. If you include someone else's content in your video, such as music, you will have to get permission from the owner. Dota 2 community stream policy. Okay, let's read that. Dota 2 community stream policy. FOV provides an in-game spectator tool, Dota TV. Okay, so this is for Dota players that makes it possible for community creators to create commentary videos and other streams of Dota 2 tournament and leagues, community streams. Anybody who runs esports tournaments or leagues or operator may publish a reasonable and simple to execute set of requirements for community streams of their events. Event streaming requirements. As a community member, you have FOF's permission to produce community streams about Dota 2 events only if all of the below applies to you. The content of your community stream is based exclusively on Dota TV and content you have originally created or licensed. I don't understand again. Okay, let's go deep again. Let's go deep again. FOF provides an in-game spectator, Dota 2 TV, okay? Anybody who runs esports tournament may publish a reasonable and simple to execute set of requirements for the community stream of their event. Event streaming requirements. I don't know. This is the start where I lost it. The what is this? Reasonable and simple to execute set of requirements for community streams of their event. Is it like programming requirements? Programming language? As a community member, you have FOF's permission to produce community streams about Dota 2 events only if all of the below policies applies to you. The content of your community stream is based exclusively on Dota TV and content you have originally created or licensed. You fully comply with any event streaming requirements that the operator may choose to publish. Aren't we the operator? Anybody who runs esports tournaments or leagues or operator may publish a reasonable as a community member. So this is distinct from the operator, from the one who runs esports tournaments. Okay, you can, so you are not the operator. Okay, that's where I don't understand it. That's the problem. You are not the operator in these terms, okay? You are just a community member. Community as a community member, you have FOF's permission to produce community streams about Dota 2 events only. If this applies, you fully comply with any event streaming requirements that the operator may choose to publish. If no event streaming requirements have been published by the operator, then your community stream must still be non-commercial. So like for esports, for Dota 2 tournaments, probably ESL and stuff. The in later in the international in Singapore, I guess not only you ask FOF for rules, but also the event organizer, right? The operator will have their rules as well. So you don't just find it in FOF, but in FOF or FOF Corporation, you find it in who held this event. In Singapore, there's got to be an event organizer company that held it, and they would have rules about streaming. I'm probably wrong. I feel like I'm wrong about this. Um. Anyway, guys, uh, isn't that reasonable? But that could be wrong. Frequently asked question. I am not aware of tournament streaming requirements for the tournament I want to broadcast. Can I just go ahead with my community stream? It is your responsibility to ensure that you have not missed them. If in doubt, reach out to the operator well ahead of the tournament. But remember, guys, you could get money from YouTube in a YouTube kind of way. You know what I mean? Like getting money from advertisements and stuff, and membership. If you have a channel that has a join button, you should be able to get that. um, and apart from that, this only regulates things that are apart from it. I'll show you later. I tried to reach the operator, but they have not answered me. Can I assume I'm fine? As a rule of thumb, reach out at least 2 weeks before the event through the official communication channels of the operator. Okay, so 2 weeks before, it's better for you if you want to make a live streaming event, or probably using the content and stuff, um, in a commercial kind of way, not through YouTube commercial, right? Just like you commercial in your content by you. You you know what I mean? You gotta give 2 weeks notice, and there's nuances in that too. Okay, so take it with a grain of salt. Don't just take my words for it. Just know that maybe there's an issue here. As a rule of thumb, reach out at least 2 weeks before the event through the official communication channels of the operator, either in English or the operator's native language. If you do not receive any response and have not been able to find event streaming requirements in spite of your best efforts, you can assume there were none. What event streaming there are none. What event streaming requirements would you consider reasonable? It is not possible to come up with an exhaustive set of possible requirements, but here are some of the we would consider reasonable if an operator imposed them, requiring producers of community streams to sign up through a free and public process set up by the operator of the event, keeping the community stream strictly non-commercial, including the logos of certain tournament sponsors of in the community stream, provided that the sponsor's products are legal in the territory that the community stream is targeted at. Usually, like gambling stuff, content would need to refer to this, having a time delay of up to 15 minutes. Okay. So we would not consider requirements reasonable if they included a payment or if they were so strict or complicated that they effectively block good faith community streams. We also encourage tournament organizers to try and reach out to streamers they think might not be complying with their requirements to ensure their awareness and give an opportunity to get things in order before taking any further action. So this is another help from FOF to community streamers. Okay, so there's an extra restriction for organizers, actually, for operator. I'm sorry. Pretty interesting. What can I do if I feel an operator is publishing unreasonable rules or is otherwise abusing the system? If you experience what you consider an abuse of this system, feel free to reach out to us at dotaprocircuit@fofsoftware.com. What exactly do you mean by non-commercial? Here it is. Here it is. Pay attention to this. Our general video policy, the one that I've read before this, goes into some detail on that. So, okay. So that falls under non-commercial. Non-commercial, it could, like, you can get revenues from usual YouTube stuff, like YouTube's ads or YouTube's membership and stuff. That doesn't, like, FOF can, I guess, FOF is not trying to micromanage that, and I guess that is beyond FOF's um, power to do that. Um, Also, we consider every stream run on a casting organization's accounts. But you know what? FOF also could prevent you from streaming in YouTube, though. Like this, they could say, like, you're not allowed to stream on YouTube, but which they didn't. Okay, and also we consider every stream run on a casting organization's accounts to be commercial in nature, even if it includes no feasible paid content or sponsorship messages. Also, if you're a casting organization or a casting channel, they would assume it to be commercial in nature, but not in YouTube, right? Now there's another nuances right here again. Now, yeah, I'm not clear about this. I cannot give you a clear answer if this is the case. So if you are a casting organization who open up just a channel in YouTube, are they saying that you are not allowed to stream in YouTube? Um, FOF video policy, we encourage our users to make video using FOF game content such as playthrough or instruction. Our use of content videos must be non-commercial. By that, we mean you can't charge users to view or access your videos. You also can't sell or license your videos to others for a payment of any kind. You are free to monetize your videos via the YouTube Partner Program and similar programs on other video sharing sites. Please don't ask us to write YouTube and tell them it's fine with us to post a particular video using FOF content, etc., etc. So this is so he so FOF is not trying to to extend their scope into that side of YouTube. But again, if you are an organization, a professional casting organization, or a professional caster, I don't know. I cannot really tell. Does this, in terms of tournaments and stuff, I can't really tell actually. I don't know. I don't know. One more thing that I feel like I'm missing out in this part about the community stream policy. Mm, is to point out, yes, I want to point this out, that the point what I'm getting from here is that FOF has the power and is enforcing it for organizers or operator that people are allowed to stream. Okay, so you have FOF's permission to produce community stream about Dota 2 events. Okay, so you are encouraged, you are protected by FOF. Okay, okay, thank you very much, guys. Uh, again, I want to say before I end this video, I am prone to mistake. I am not a professional. I am just excited, or I'm just someone who cared about this, and I want people to I want to get better until to the point where it is easy for me to relate to people and convey this aspect of um, relationship, legal relationship between people in the internet with everybody. But again, if I've said anything wrong, then I would be wrong, guys. I'm not giving a professional guarantee or a professional opinion, or some kind of reliable insinuation that about any of this stuff. uh, Okay. If you have something serious or high stakes or whatsoever, please consult your professional legal counsel. Thank you, guys.